spending your lunchtime with us. We are going to get started. There are a lot of cases to get through, and we want you guys to be able to absorb all the information and then use it at 1:30, presumably at 1:30. There were 40 some odd cases that were published in 2017. We're not going to go through all 40. We picked 38 of the cases that we thought would resonate with you guys in some way, shape, or form. Even if not directly as a parent's attorney, but certainly something that's kind of going on in the atmosphere that we thought you should be aware of. So with that, we're going to get started.
So we have about 1 minute and 28 seconds per case.
Okay, so hi, I'm Christina Samons, one of the writ attorneys. So first I'm going to start off with some early issues that happened early on in the case. We've sort of structured it that we're going through the life of a case. So starting with detention, paternity issues, going to TPR. And before I begin, I just want to say that it's really important that you guys read these cases if you do plan to use them. I know that you all know that, but just because we bring out little bullet points doesn't mean that you shouldn't read it. Because you got to check us. We don't know everything, so you got to check us. So in Re LL, this is about parentage, and this is specifically about a third parent. So as you can see here, basically the child lived with mother and a non-biological father, TL, for almost all her life. And the biological father was incarcerated for manslaughter, didn't have any contact with the child for 6 years, and the child was 10 years old at the time of detention. But he had legal custody of the minor through family court. And so in the trial court, both fathers, wanted presumed status. And so there was big argument first on, does the biological father even qualify under 7611D as a presumed father? And then two, should the court find that there are 3 parents in this case? And so basically what happened is that on the first prompt, the Court of Appeals said that definitely this biological father did qualify. So what's important to know is that a biological father doesn't have to have a current relationship with the child to be found presumed. It's strictly the factors under 7611D. A lot of times people try to say, or county counsel, minors counsel will try to say, oh, he doesn't know this child, he hasn't been in the life for X number of years. Doesn't matter for a parent to be found presumed. However, what the Court of Appeal did do was reverse the finding that the biological father should be found the third presumed parent. And the reason was that the court used the wrong standard. So Family Code 7612C is clear. The standard is that a court may find that more than 2 persons are parents if recognizing only 2 parents would be detrimental to the child. Now what the court did, and what a lot of people I think sometimes do, is think, oh, well, I'm going to find 3 parents because it's not detrimental to find 3 parents. And I hope you guys see the difference. So the real standard is that you can only find more than 2 parents are presumed if it would be detrimental not to. And in this case, it didn't meet that burden because current relationship with the child can be considered under the factors of 7612C, not considered as a factor under 7611D.
All right. Next on the list, following statutory discussions of cases, is Brianna S. In that case, the department had known of mother's Indian heritage. She had told the department, as well as filling out the ICWA 20 form at the initial hearing, that she knew of Apache and Yaqui Indian heritage. She also told the CSW that the maternal great-grandmother of the children belonged to the Yaqui tribe. So there was reason to know that a child might be eligible for registration. The problem here is that the notices sent by the Department of Children and Family Services to the tribes was insufficient. They had the information, as you can read through, they had the information about the biographic information, I should say, about the grandparents and the great-grandparents. They just didn't include it. So when the tribe receives the notice, without the information they need, they can't make a determination of whether this is possibly an Indian child or not. And the letter that they wrote back explained in the assessment that they needed, that it was only based on the information provided. It turned out they were members of the Indian tribe. And so there was a second issue having to do with mother's drug abuse, and it ended up at the 2.6 that she did not meet the exception under 366.26 C1B Romanet 1. But the case stood for the fact that you need to send the proper notice. What has happened in the past, though, is that some courts, at least on remand, have asked the parents' attorneys, in dicta at least, to get the information and present it to the court. The burden is still on the department. It is by statute, but just make an effort to get all the information about Native American heritage that you can so that it is presented. So this was a case of limited remand, and if you need to read about limited remand, it sounds like Sesame Street. It's In Re Francisco W., a 2006 case at 139 Calab 4th 695. It's an interesting case to read about, Civil Code 43.
And if you guys have questions while we're presenting on a case, feel free to raise your hands and ask. Okay, so continuing on ICWA. This is one where the mom comes into court, she says, oh, I think I have Cherokee ancestry, but I'm not sure through which relatives the ancestry is from. She suggested some relatives that may have information, however, those relatives were deceased. So this appeal actually arose at a TPR. And so a lot of times at a TPR, maybe there's not so much to argue on appeal, so you're like, ICWA, yes, I'm gonna win on ICWA. Because you have nothing else. That in reality, in this case says that the court complied with everything by finding that this case was not an Indian case because the mom only had vague statements. She didn't know what relatives really had the ancestry. The relatives who had more information were deceased. Like I said, they were just vague. And so just a heads up, that family lore, people saying, oh, I think that I heard my grandma said that her father was Indian, that might not be enough to trigger the Indian status, but of course you have to ask your clients, you have to write it on the ICWA 20 form and just give all the information to the court. If the court is just challenging you on it and saying that ICWA doesn't apply, you can make your objection, but don't worry about it so much.
Okay, so moving from ICWA to the UCCJEA. This first case is In Re AC. It's more of a cautionary tale than it is anything to actually get a rule of law out of it. Just to, get quickly to this holding. So the court is not required to verify and authenticate that its email inquiries to the home state were received. And it could conclude that the home state declined jurisdiction by its failure to timely respond. So this is really the actual holding, but then there's this other part which is for you guys. The other part which is for you guys, and before I get there, let me just double check. So the UCCJEA, it's the Uniform Child Custody Jurisdiction and Enforcement Act. That is its full name. We commonly just, UCCJEA, that's the full name. It is in the Family Code section, beginning with 3400, continued on. The Family Code section that deals with the UCCJEA, it starts with 3421. The parts in the beginning is important too, but 3421 is where you're going to really start zeroing in. Okay, they set forth the basis for subject matter jurisdiction. And just while we're on that subject, it talks about this particular case says there's 4. I think there's 6. The only reason why I think there's 6 is when you look at this section, you see it is written in the disjunctive. It's, first this clause, comma, then this clause, comma. You have to run through all of the clauses to see where your case falls in before you can say, oh, it's this one. This is the reason why we are taking jurisdiction over this child, why California is taking jurisdiction over this child. And then, let's see. Then, when you get to the reasons why California is going to take jurisdiction, you got to do some analysis. And I can tell you, when I was doing UCCJEA, I was just trying to figure out if it's 6 months. Has the child been here for 6 months? It is way more than 6 months. If all that you guys are doing is counting 6 months, I don't know when you're starting, when you're ending, you've done the analysis wrong. You've done the analysis wrong. So look at this. There must be an inconvenient form, an unjustifiable conduct, a significant connection, and a substantial evidence analysis to determine if the court can take subject matter jurisdiction. So it's really, it's pretty intense. So I say all that to say up front that eventually I'm going to run you through another case that actually takes you through. But that's what you just need to know just going forward, that's what UCC's JEA is all about. This case was a cautionary tale because the trial court attorney did not raise the kind of issues that needed to be raised for this record to be reviewed. And then, because the trial court attorney didn't raise those issues, the appellate court attorney kind of made stuff up too. And so the Court of Appeal was done. They're like, we can't even review this. They said more than that, but they said not only were these issues not raised, and I'll go back to the holding, the appellate court attorney said that subject matter jurisdiction or the UCC JEA did not apply or was not complied with because the bench officer never verified that its email to the home states were received. Trial attorney never raised it. Never raised it. Appellate attorney made it up. So make sure that when you are in any issue, but particularly this one, if there are issues to be raised, be real clear about what you're raising so that appellate attorney, if this case is going to go on review, can pick them up and run with them. So this is about forfeiture. I'm going to move on because I don't want to waste our time. In re Aiden L. So the holding, the court must hold an evidentiary hearing to determine the child's home state. Stop! That's the first thing you gotta do. You must determine the child's home state. Cannot do anything more until you figure that part out. And then decide if it has subject matter jurisdiction based on an evaluation of the facts at the time the dependency proceedings are initiated. So that's when the petition is filed. Those are the facts that you're evaluating. So I remember there was sometimes a point in time where I was like, well, the child's already been detained here in Cali, and by the time we get to Jersey, it'll be 6 months. So, no. At the time the proceedings are initiated. All right, so let me go through. So, home state, it's defined. Where is it defined? 3402G, Family Code. It means the state in which the child lived with a parent or a person acting as a parent for at least six consecutive months immediately before the commencement of the child custody proceedings. So that's where we're getting the 6 from. But notice where they want you to start the time. They want you to go from the petition filing backward. Okay? Then, okay, in the case of a child less than 6 months of age, the term means the state in which the child lived from birth with any of the persons mentioned. That's Family Code Section 3402G. Okay, that's when you get the baby. When you have a baby, you're like, ooh, where's the baby? Okay, then lived. What does it mean to live somewhere? It means your physical presence. Now there was, in the case they talked about, well, what about reside? No, just where you lived. The physical place where you lived. And then, included in there, a period of temporary absence of any of the mentioned persons is part of the period. And the reason why they say that is because sometimes you leave a state, you come to Cali, but you don't mean to stay. You really mean to go back. And that's why Aiden L was published, because they weren't quite sure. The parents, they had some kids here in Cali, they had all their kids in Arizona, and then they brought Aiden to California, but it wasn't quite sure whether or not they were going to stay. There was this other issue about whether or not they had charges pending in Arizona, so they hightailed it out of there to get to California. So you got to figure out all of these facts when you start figuring out home state. A temporary absence requires consideration of the parent's intentions as well as other factors relating to the circumstances of the child or family's departure from the state where they have been residing. So this is why this case was published. Because you gotta get to the home state You got to do that factual evaluation. Then you got to jump to subject matter jurisdiction. And the other reason why A to N was published is because not a single solitary person raised it. They just did the case. And then it wasn't until after termination of parental rights that the court was like, wait, and had to redo it all.
Okay, so this case is a little fun, I think. So Johnny W. versus Superior Court of San Francisco. This case is about 170.6s. And 170.6 is an affidavit of prejudice that people file when they want to change courtrooms because they believe that the bench officer is biased or prejudiced in some way. I'm sure a lot of you are familiar, but just so you know, the actual statute is pretty long, but this case involved the use of that. So what happened? The 300 petition was filed February 8th. Father's counsel requested a one-day continuance for contested detention hearing. So the court granted that and made temporary detention findings. Then the next day, when the father's counsel comes back to court, he files a 170.6. And the court's like, no, I made rulings yesterday, I made the detention findings yesterday, and I'm not going to transfer this case. Then father filed a writ of mandate challenging that, saying that the court should have granted the 170.6 because it was timely. And the Court of Appeal agreed. So the 170.6 rule is kind of complicated, but essentially our court we consider an all-purpose courtroom. There's signs posted outside that say this is the courtroom for all purposes. That means that your bench officer is hearing the case from beginning to end, right? So in that system, you have 15 days after notice of the bench officer that's hearing the case to file the 170.6. But you have to file a 170.6 before any contested issue of fact is determined. Now, the county council was trying to argue that the contested issue of fact was determined, in fact, because the court had made those temporary detention findings, and so therefore there was a finding that the kid should be detained from the parents. Okay, however, in Johnny W., that was found to be insufficient reasoning because, in fact, they said at a detention hearing, no contested issue of fact really is decided. So it opens the door to say that really the contested issues of fact are only decided at the jurisdiction or some sort of other trial, but it has to be a full trial where there's evidence presented. And the Johnny W. court said that just the county council entering the report, DCFS report, as evidence at the detention is not enough to say that there was a contest on that. Even though the attorney argued that the children should not be detained from the parent in this case, doesn't mean it was contested because it was a detention hearing. And so if you want to have the expansive view, this is why I wrote narrow view versus expansive approach. I think that I've just made up those terms, but the expansive view would be that even after a real detention hearing, not just temporary detention findings, you could possibly file 170.6 and have the case transferred to another courtroom if you believe that there is bias on the part of the bench officer. The narrow approach would just say, no, this is a limited circumstantial decision where it's different because it was only a one-day continuance, it was only temporary detention findings, and so in this limited circumstance it was okay, but possibly if you try to file after a full detention hearing, maybe you wouldn't be able to get away with it. So I submit that matter to you guys and I hope that you read it, but personally I think that this case supports an expansive approach and that you can file a 170.6 within 15 days after the case being assigned to a courtroom. And lastly, I think best practices, defer to your supervisors, but it's smarter just to file the 176.6 immediately if you know, one second, if you do think that the bench officer has a problem with your client or whatever, it's better just to file it sooner. Why wait? And second thing is, be ready for a challenge from your bench officer because they might say, what's your authority? What are you talking about? No, I'm not transferring this case. I already did detention. Be ready for that. Okay, question over there?
Is it court days or calendar days?
It is calendar days. It's calendar days.
It's not 10?
No, actually, I just checked the CCP today. So it's, right? Yeah, no, it's 15.
Oh.
It's 15, okay. It's CCP 170.6. I just looked at it today and it said 15 for the all-purpose court system. Okay. Oh, yeah.
Jurisdiction. So this case probably is not as helpful for us, Parents Council. This kid, he wanted to be in the system, right? He wanted to get the extra support that a non-minor, because he was 17 when the petition was filed, he wanted to get the extra support that is afforded to non-minors when they get past 18 to 21. Unfortunately, what happened was the trial court dismissed the case. Like, no, there's no jurors here. The thing for us to know is that the Court of Appeal cannot direct the juvenile court to take an action that is beyond the scope of its legislatively conferred power. So this kid, he wanted jurists, the trial court dismissed, he filed his NOA and turned 18. So the Court of Appeal was like, what can we do? Even if we thought that the trial court could have found jurists, we, the Court of Appeal, cannot make you 17 again. You are an adult, and we, on our own, cannot open up jurisdiction. You have to be under the age of 18 in order for jurisdiction to apply. Marlene.
Question. Jurist, court finds allegations true, kid is 17. Dispo gets put over, kid turns 18. So at the dispo, when the child becomes a dependent, that person's no longer a child.
No, you have to be declared. You have to be declared before you turn 18. That's what happened. He turned 18 after the court dismissed. So in the process of filing the NOA, he was already out. And the court...
Right, so the same theory would be if you have a bifurcated jurist and dispo.
Oh.
That's what I'm saying. You have jurists in which the court sustains. Then by the time you get to dispo, the person turns 18.
How do you declare them a dependent?
So that's my question.
Yeah. No, it's got to get done. It's got to get done while they're under the age of 18. Go ahead.
Well, I disagree. Look at the case of In Re Gloria A. from 1988.
Well, no, explain it so that we all can benefit.
It means that the petition has to be resolved before a child turns 18. Okay? We have non-dependent minors now, so even at dispo, the declaration of dependency would be of a non-minor dependent at that point. So I'm confident that we would continue asserting jurisdiction. Parents may not have anything to say anymore, but the child will still be in the system.
And there's legislation pending to clean all that up.
Yeah.
And make it so that it doesn't have to be adjudicated before their 18th birthday.
Right. That's it. That's the answer. Okay. Who's that?
So just a quick note on In Re Marcus C, which was a case that was published last year, and it was actually depublished. So it's not bad law, but it's just not citable. I just wanted to make a note on that because it was used a lot by county council to amend petitions to proof by adding things that weren't actually in the petition.
Is that Zeke's case?
Yes, that was Judge Zeidler's case.
So why was it depublished?
Because it went, they sought review in the California Supreme Court. The Supreme Court denied the review and ordered it depublished. Or they say ordered not published, but it was already published, so it was depublished. But they're not disapproving it, it's not bad law, like I said, it's not published anymore. So the reasoning can be used, however, I don't think it's citable, so if county council tries to cite it, you can just one-up them.
Okay, another jurisdiction case. Okay, Alexander C. This was not a good case for us, parents' attorney. So here's the holding. The functional use of methamphetamine supported a finding of substance abuse where the evidence satisfied the criteria for substance abuse disorder in the DSM-4. So the focus here is the fact that these were functional users. And for a very long time, we have been able to make no nexus arguments. We've got Drake M, Destiny S, Rebecca C. We've been very comfortable with being able to distinguish the difference between someone who's a functional user and someone who actually has a substance abuse problem. With Alexander C., just so that you can kind of hear why it's a little, it rubs me the wrong way, and it should rub you the wrong way. The parents were functional users, so good that our kids never knew about our drug use until now that this all happened. The father was employed for 29 years in the same government agency. He had no criminal record. The children were current in their immunizations. They went to the doctor when they were sick. They had A's and B's in school, perfect attendance, never late. The children never saw the parents using, never knew the parents were using, never saw the parents under the influence. They had enough food, they had enough clothes, they were not abused in any way, and the parents were testing clean at the time of the juris. The problem is that for us, Rocco M., 1991 case, that particular case spoke about creating a home environment, providing the children with the means, the opportunity, and at least the potential motives to begin abusing drugs. So the court reached back, or maybe it was appellate counsel, who knows, but they reached back, they pulled this very substantial holding from 1991 and used it to apply to the facts in Alexander C., where these parents were like, you know, we need it. We can't function without it. It's been so long that, you know, our tolerance is so high, and it just keeps us going. We're able to function. Those factors, being able to, or not being able to function without it, it's a habit. I need more and more. Those kinds of factors fall in the DSM-IV as some of the factors that diagnose you as having a substance abuse disorder. So that's the first prong, right? That you have a substance abuse disorder. So it didn't matter that they're functional, they qualified. Then the risk part, well, what's the risk? The risk is that they created a home environment where these children could pick it up because they see their parents doing so well and doing so well with this drug. And yeah, they didn't know about it, but they know about it now. And at some point, maybe they could have found out about it. It was a bad home environment. It sent the bad message. It sent the wrong problem-solving skills to the minor kids. That's how this court found jurors here. So you're going to have to distinguish the heck out of your cases. You're going to have to dig through the DSM-IV. Do the best you can because Alexander C. is here.
So next we have one of the series of cases of a one-time incident under Section 300B. As you'll read through, mother was stopped and arrested by the California Highway Patrol. She was driving with a blood alcohol content that was 0.14. She had told the officers that she had come from a place where she just had had a couple of drinks, but further investigation turned up a few other things, that she showed a history of conviction for drug use. She had a DUI. She was on 3 years probation. This was still filed as a non-detained petition, however, because they left the children with the father. Mother arrested, had a criminal proceeding. Part of the criminal proceeding, she was sent to counseling programs. And as investigation went on, the parents just showed a complete lack of contrition to the situation they found themselves in. They couldn't understand why the department was getting involved or why they were at the Juvenile Dependency Court. They saw no need for intervention. The court, however, found there was a need for intervention because of the lack of contrition, because of the parents' attitude, because that mother couldn't identify a beginning and end date for the counseling program she was ordered to attend. And because of that, the court ordered, actually they did a 360B and released the kids. The kids remained released to the parents because they were at least testing clean. And they had just challenged the finding under the petition and the fact that this case could go on for another 6 months to a year under 360B of supervision. So this just teaches you be nice. There's to the police. The two other cases you know by comparison, there's JN, a 2010 case, at 181 Calab 4th 1010. That was where the father was drinking, drunk, he was under the influence, so was the mother as a passenger. Kids were in the back, and he ran into a light standard. The difference between that case and this one was that the parents admitted to drinking like fish and water to the police. The father immediately got into a program, even though he too was arrested. Mother got into a parenting class. By the time the disposition came around, they were pretty much done. They had no criminal record at all. They admitted their problem and promised never to do it again. And so the case went away. There was also a case of J.K. from 2009, just a year before, at 174 Calab 4th 1426. That was a case where there was a father who had sexually abused his daughter 6 years before, had beaten her badly 2 years before, and now this third incident came up. And all this historic information on the father came back to haunt him. It showed a pattern of behavior of the father toward the daughter that placed her at risk into the future. And that's why the court took jurisdiction in that case, even though the father was claiming that the most recent abuse was just that one-time incident. So there's a big difference in the cases. That's why it's so important when you read the cases to factually distinguish them one from the other. Yes?
I just wanted to add about this case and the case before from that.
Speak up a bit.
Oh, that those cases are actually pretty distinguishable. We rarely have facts where, in the prior case, I think the father's meth use was 25 years, and the evidence showed that his use of meth had actually increased substantially over the last 2 years, meaning the type of dependency he had on it was starting to be worrisome. Plus, his kids were 12 and 14 years old. And I think the Court of Appeals language was that one could easily fathom that enterprising youth of that age would easily be able to find meth in the home, when the evidence showed that all the times that meth was used was inside the home. So it would be easy for children of that age to find them that. If the children were younger, they may be able to distinguish that. And for this case, the criminal court had actually ordered probationary post-conviction orders, which the parents, or which the mother refused to do.
I think that methamphetamine just falls under the Breaking Bad exception,
Right.
which you'll find discussed at 22 HBO 3rd, page 17. We just have been fun. Okay, thank you for the laugh.
So there are a couple cases about mental health and mental illness being jurisdictional. So I've outlined what I thought were the good facts and not so good facts on the handout. And the Mother's Counsel's arguments were actually very, very good. I don't know if anyone here was on this case, but the minors were never actually harmed by Mother's conduct, which was true. Mother had delusion, she was paranoid, she thought the government was after her, but the children were never, ever actually harmed. And the second argument was that any risk to the minors due to Mother's mental health was purely speculative. However, unfortunately, Court of Appeal ruled against that and said that the trial courts don't have to say exactly how a child is going to be harmed, just that they believe there's a substantial risk of some sort of harm. And in this case, the bad facts just outweighed the good facts. So make sure you distinguish this case if you have any mental health allegations against your clients.
Oh, this is a great one. This is a fantastic reversal. It's jurisdiction regarding mental health. And here's the thing about the sticking point for this one. So we all know a history of mental health, mental and emotional problem is insufficient to establish future risk of harm in the absence of evidence of current risk. This is the stealth/hidden reversal. There were so many facts in this case that the court devoted 10 pages to the facts and only 3 pages to the discussion. The reason why I point that out, you have to go and you have to just wade in these facts. 10 pages worth of facts mean that there were many, many things that could kind of catch you by surprise, and particularly in mental health cases. Behaviors that don't quite seem to comport with infant care. The brilliance of this particular case is that no matter how hard the facts got or how disturbing the facts got, it was a reversal from the very start. It was a reversal from the very start. So, you may have an eccentric parent. That may just be what's going on. If the eccentricity, all those facts, all the weird things that are being quoted of your client has nothing to do with the care of the kid, go for the reversal. Ask for the dismissal.
All right. Okay, in the case of In Re AL, in this particular case, mother had suffered mental illness. For the last few years, she had refused to take her medications. She was staying in her bedroom a lot. She wasn't interacting a whole lot with the family, but every now and then she'd have these explosive behaviors, which the children were exposed to. In this particular case, mother threw a shoe at her daughter. The daughter wasn't even sure if the shoe grazed her head or just sort of deflected off her arm. The son sat between his parents when they would argue and yell at each other on the couch. But AL told the social worker that there's plenty of food in the house, they feel safe at home, they understood that his mother was a little bit crazy, but she would never do anything to hurt me. The daughter felt the same way, and the court found that the evidence insufficient to show that the children had suffered actual harm. And one sense you get from reading these cases, first under subdivision B, there are 4 reasons that we take jurisdiction, all of which describe situations where the circumstances the kids find themselves in may indicate a substantial risk of harm to their physical and or emotional health and safety. That's why we intervene. We don't intervene because of mother's mental health, can't do that, or intervene because of drug use, unless the children themselves are put in an environment where there's a substantial or potential risk of harm to them. So this was another case where there just wasn't enough. Even though mom's was crazy, she still would never do anything to hurt the children, and so the court dismissed the case.
So now 2 cases that have the opposite result regarding weapons. Again, the facts matter, so if you have a case about weapons, please read these cases, especially in Ray's CV, which found that there wasn't enough to sustain a weapons charge because this child was 3 months old and an unloaded rifle and ammo was found in a backpack that was wedged between a wall and a bed in the bedroom, where the child did sleep, but the child was 3 months old, couldn't really go up and take the backpack out. And now that's contrasted with Yolanda L., where a loaded handgun, plus ammo and extra magazines were found in just a nylon bag in a closet that was within reach of the child, the 4-year-old child. So again, facts matter. You have to make these distinctions in the facts between your case and the published cases.
Okay, this is our California Supreme Court case, In Re RT. Bottom line, you do not need to find a parent at fault or that they are blameworthy in order to take juris over the kid. How did they get there? They just looked at the code. And you look at B, it's B1, it's this huge paragraph. But again, it's written in the disjunctive. Clause by clause are the basis to find a kid under Section 300. The first clause, it just says you failed, you're unable to supervise and protect. That's it. That's it. All the other clauses, you see, oh, you have to be neglectful, oh, you have to be willful. That's when you start getting into all of that describing behavior. But that very first clause says nothing about whether or not the parent was at fault. You just can't take care of your kid. You can't supervise your kid. Your kid is running wild. And the Supreme Court had enough sympathetic comments throughout. They are very sympathetic to parents who are in this situation. Bottom line is that they're not going to spend time picking out who is to blame. The kid needs help, and the dependency system was designed to help this particular kind of child. So Precious D, no more. Rocco M, maybe. Priscilla A, that was a published case that came out just before RT, depublished. They had to go back and do the case over again because RT came out. So then they ended up affirming the trial court judgment, finding juris.
So D count and B count, just so you know that you guys, again, argue the facts. If one child is differently situated in some sort of way, argue that, because the Court of Appeal found convincing in this case that sexual abuse on an 8-year-old was specific to her. The older daughter was not likely to be abused because she was more outspoken and would report the abuse. And then the 2 boys were boys, and they were younger. So again, facts matter.
Was that published?
That was published.
Okay, in the case of Carl H., this was a case where the most important thing that came out was California Rules of Court 5.695, which lists all the orders a court can make at a disposition, including dismissing the case. The child, Carl, lived first with his mother, then came to live with his father. His father, and they all lived in the grandmother's home. One time when Dad was in prison, Grandma dropped one of her methadone pills, asked Carl to pick it up, and sort of popped it in his mouth, and he ended up going to the hospital because of methadone toxicity. Later on, Mother, who had 2 children with another guy, moved in with her first love, Carl Sr., and she brought her 2 daughters with her. While at the home, one of the daughters crawled around in grandmother's not very clean house and ate some more methadone and some other drugs and died of toxicity from the drug overdose. Dad's claim was that, well, when I'm in jail, I don't live with my mother. I'm not really the custodial parent of my son, Carl. And the court ended up making a family law exit order in which they applied 361.2, found that he was non-custodial, released the child to the father. The agency, in this case, appealed. The court said, no, you have to be a non-custodial parent for 361.2 to apply, because it's a dispositional placement statute after all. And you were. You lived in the home, you took care of Carl, you knew drugs were there. He falls within A, B, and Carl was also found under J, not as the dad, but as to the mother who is living, in the F rather, but as the J as to the mother. The court also said 390, this isn't a dismissal of the petition, because in order to do that, it has to be in the interest of justice, and the welfare of the minor requires the petition dismissed only if the parent is not in need of treatment or rehab. The father was a drug user because he used to get high with grandma sometimes. And so the case was reversed and sent back. We have only 10 minutes, that's why I'm talking so fast.
Sorry. Okay. For me, for this one, I put high school boyfriend prevails. For this one, so there was a lot of issues. I'm just going to focus on the one that I think really stood out. So termination of dependency jurisdiction with a juvenile custody order granting sole legal and physical custody with a non-biological presumed parent is not an abuse of discretion. So, like Christina said, you find presumed parenthood based on facts, not on biology. Oh, let me see if there's anything more. This particular parent not only was able to get custody of this kid, but skirted around ICWA. There was issues raised about whether or not the biological parents had Native American ancestry. This court was like, that's a different case. We don't want to get into that right now because this guy's presumed. He's not the one claiming Native American Indian ancestry. So the question still is kind of out there. Does the court still need to do ICWA notice? that's another issue for another time, but the bottom line is that as long as you can get presumed father status, you can, or presumed status, you can get the kid, and the biological parents, they're gonna have to watch you do it.
Okay. All right, Destiny D. In this case, let's see. This was a case where, by the time the case got to disposition, this was out of Judge Soto's court. It was found that the child was sick, children were safe with mother, there was a restraining order in place, the dad had a long history of alcohol abuse, and there was DV, and, but mother had the skills at that point to protect the kids, dad was not going to be back in the home, there was no reason for any other orders to be made to protect the children, mother was doing a fine job. In a case like this, you don't have to set, as the minor was arguing on appeal, a post-dispositional review hearing under 364 where there's family maintenance. So it was fine to issue the custody order and terminate jurisdiction, as opposed to the other case where Carl, where the father still needed a lot of work. But this was a lot more clean. There was no reason for any further intervention. So the Court of Appeal affirmed the dismissal.
This is an E case, and it was not a good E case. Both parents denied committing the abuse, but then the mom worked with the police and did a pretext phone call where she got the father to say that that he caused the injuries. He didn't say, "Oh, I abused the child," but he said, "Oh, I think it was when I pulled the child's leg." Anyway, all of that was brought in at trial. The court sustained the E and denied FR to the father. On appeal, the father challenged the confession by saying it wasn't credible. And two, he also challenged the fact that 3 experts testified at trial. 2 of them said that the injuries were not caused by abuse, and 1 said that it was. So he said that the court improperly relied on the 1 doctor instead of the other 2. Bottom line is, the Court of Appeal is not going to reverse any credibility determinations of the lower court. The lower court makes all of those findings, and the lower court believed the father's confession and believed that 1 doctor over the other 2. So what are you going to do? But you got to try. You still got to put on your case, make all those objections, and you got to try because you never know if your case will be different.
Jennifer S. This is bypass pursuant to 361.5B10. I called this case, I feel so bad for these parents. Recent efforts to treat the problems that led to removal of the sibling are not reasonable, where the parents' efforts came too late. I mean, we have this client all the time. The client that they've lost their kids, you know, they didn't do their FR, they had this new baby, they do their FR, they're visiting, everything is great, they're testing clean, or whatever they're doing well. If it comes too late over the entire history of how they parent children, it is potentially not going to be found reasonable, and you're not going to be able to get them FR.
In the case of AF, it's also a disposition replacement issue, but this had to do with the Indian Child Welfare Act as well. Okay, that's why I'm going to explain it to you.
They won't be able to get through the entire handout, so we will email everyone the handout minus the dark sheets for the ones you can't see, so
Right.
you'll get those.
Okay.
Maybe slightly larger.
We'll send it. What we'll do, we'll send you out just the frames without the
All right.
lines. Anyway, to continue. Okay. Anyway, AF. AF lived with his father, WF, who had no middle name, and so it's actually funny. Anyway, he was living in his trailer home with his child. Grandmother was on the same lot. A girlfriend moved in with her daughter. Father ended up killing that daughter. And so he never got FR. The mother got FR, but she was only sporadically visiting. Anyway, what it came down to is that the mother had nominated her maternal cousin as a caregiver. What happened is the court looked at the California ICWA law as well as the federal, and it was determined that when the court at the dispo transferred the custody of the child from the maternal cousin to the grandmother, it was because it could do so because the tribe, although they had recommended the cousin as the place of caregiving for the child, the grandmother had always been involved, had a superior place in the ranking of orders among those who were equally entitled to placement. And because the tribe did not pass its own resolution or equivalent containing a different objective order to keep the child in the maternal grandmother's home, the appellate court said that the child was properly replaced to the grandmother because she was hired in the order to receive the child. That's pretty much that.
So in Res CM, the holding was that a trial court cannot make a dispositional order requiring a Child Protective Services agency to detain from a parent upon a certain event occurring. So what the order in this case was that in the dispo order was that the CPS should detain from the mother who had returned at dispo if there was evidence that she allowed contact with the DV father or violated a restraining order with the DV father. Okay, that's no good. The court can't delegate that authority. They can't make a per se detention because the duty of the social worker is to evaluate risk. You know, they're calling in a referral. Then the social worker is supposed to investigate. It can't be this per se detention that's ordered at the disposition to remove. And what is the proper procedure for detaining a child from parent after dispo? 387.
But they can do it backwards. They can make it
What do you mean?
conditional, like the department is to release to the parent if they do X, Y, and
Yes,
Z.
correct.
Did you do IF already, or did you do Matthew?
I'm going to do, okay, Matthew C. I know that's ridiculously long. I'm going to make it really, really short. Mom and dad, DV, mom uses drugs, really bad. Ended up getting the child back, lived in a home with him for a while, but then left the home, found a new place to live with the child, ended up getting in a big fight with dad where she was beaten up, hospitalized. They ended up abandoning the child at a Starbucks along with a bottle of vodka that was left for the child to drink because he was lactose intolerant and couldn't take a latte. So the problem was that, thank you so much, one fan. So anyway, there are two approaches to visitation. One, from the case of NRA CC, is where under 362.1A, 1B, there has to be a showing of safety. The idea is that you need to have visitation with the child in order to make a pitch later to receive custody back. Under a more expansive view that this court agreed with the 3rd District, that you look to the well-being, and that can include the emotional well-being of the child, not just physical safety, as was discussed in Race CC. So I guess you have to keep in mind real fast, I'm sorry, but California does not have a vertical kind of review. Each division of each district can come up with their own decisions, and that's the law of California. So just pick your facts and apply the case law as you will. The California Supreme Court is the one where the decision of what the law is, applies. So that ended up being sort of apples and oranges, but in the end, we're all fruit. So, thank you.
So reasonable services, this is at the disposition. This one, after I read it, I said, really? Really? Okay. The dispositional order was for the parent to attend services in English. He didn't speak English. He didn't speak English. That's a no-go. You object. You cannot allow you guys are going to the speed of light. Here we're at the dispo. Here's the order. Everybody signed it. You looked at it. You looked at it. If he doesn't speak the language that the services are being offered in, object. It's not going to go anywhere. This was this case.
What do you do when there's no interpreter available?
Let's get through the cases. Let's do the case. Very easy. Here's the thing. The Court of Appeal didn't even know what to do with this. They just knew it was wrong. They sent it back, but didn't tell the trial court to do anything in particular. They're like, handle this. They couldn't even come up with a relief because the case had already been JT. But it was so egregious. And this happens all the time. So egregious, they couldn't sit on it. They were like, we just have to publish this. So our lesson, cannot let this happen.
Nicole, so do you suggest that we make sure that our dispositional case plans say that the services are to be offered to our parent in Quiche, whatever
At a
language it
minimum.
is, or that the department
At a minimum.
provide an interpreter for those services?
Yeah, but here's the thing. The reason why this was published is because everybody knew it. So it wasn't that even the way she tried to cure it. You know, oh, it's got to be, he needs language assistance. It wasn't available. It wasn't available. So it doesn't cure it by saying, well, you know, do you help him with the language? No, it's not available. It's not going to happen. Objection. Got to come up with something creative.
Like what?
Something creative.
That's at the next one.
Again, the Court of Appeal didn't even try. They're like, we're not saying what to do. We just don't like
I mean,
it.
to cover our butts though, or should we include
Just object. Just get it on the
language that
record that this
they
is not
should
right.
Provide an interpreter, that they should provide
All of that.
services that are reasonable to our client, meaningful.
At the end of the day, it's the court's job to make sure that they are ordering services that can actually be participated in.
Okay. Father was deported after, this is AG. Father was deported after he was arrested for assaulting the mother. Later, a 300 petition was filed against the mother, which substantiated her neglectful acts toward the children and alcohol use. By the time they got to the 12-month review date, the court found that father living in Mexico had been offered services. The appellate court reversed, saying that that was not the case. Specifically, 361.55E1, subpart E, talks about reasonable efforts to help parents. But there should be an S after the parent so that the verb matches the noun intent. So anyway, the court found that services weren't given. DIF wasn't tried to become involved, but the local agency here never really participated in giving any guidance, and the court said that that was not harmless error. You have to give services, the statute says, and the father's waiver, so-called waiver, of saying the kids can stay in the States because I can't afford to pay for their school, didn't demonstrate that he had an informed understanding of what his responsibilities were under the disposition case plan and didn't receive services. So it was sent back for an additional time for father to get services.
This is a good case if you're arguing no reasonable services to an out-of-state parent. The father in this case was in Florida. I recommend that you read it. And just one sound bite that was great is, although the likelihood of reunification with father may be low, he was nonetheless entitled to reasonable services, because the department tried to argue like there is no way he was going to even get his kid back anyway. He's in Florida. He's not going to come to California. Doesn't matter. So this is a good case.
I don't even know if I should spend even 5 seconds. Your 388 has to come before the 26. This came out of our courthouse. The 388 cannot come after the 26. 388, then 26.
Another crazy order. Oh, sorry. Next one. But basically just the bench officer didn't appoint counsel to a mom who had filed a 388. No. So just be vigilant. Don't be afraid. Like, you should get appointed. You need to help these clients out.
Here's another appointment of counsel. Came out of this courthouse. She has parental rights. She comes in. Her kid was in a probate guardianship. This is the dispo. The court was like, I don't know why you're even here. You're not a party. She has parental rights. It's not over till it's over. It's not over till it's over. Your parent has parental rights and they're coming forward. They're getting a lawyer. Ooh.
So, okay. Very quickly, this is well-established law, but it's just another case saying that the trial court must make a finding of parental unfitness or detriment by clear and convincing evidence at some point in the proceedings before terminating parental rights. This is a must. It's constitutional. A Supreme Court case, Santoski versus Kramer, laid the foundation for this. So just, it has to be done at some point, and if it's not, no TPR.
In Ray JS, okay, there's a lot more facts to it, but what it came down to, got to the 2-6 hearing, mother ends up having custody of an 8-year-old child who wasn't part of the dependency system. The child got along really well with the minor who was at the adoptive home, or the one identified for adoption, and the court would not let mother testify as to the relationship in order to demonstrate 366.26 C1B5, which is the sibling exception. It wasn't, again, it was not harmless error. The mother was deprived of a substantial right to testify, which could have, even though it was difficult to overcome, could have had an effect on the outcome of the case. The case was remanded to give her a chance to testify about the sibling relationship.
Do you guys have any questions about any of the other cases? We're almost done.
Just
Can I
one
do
section.
one more?
I have one case. On that Louis H.
Yes.
Louis H. Was there also in that case a suspicion of a lack of truthfulness on the part of the 8-year-old?
No,
No?
not in the Court of Appeal opinion.
Wow.
But the 8-year-old had a, quote, particularly shy nature. These was the exact court finding. She found that that child had a particularly shy nature that made her more susceptible to the abuse by the mom's boyfriend, which none of the other children had. And it was just a good record by the trial court.
Wow.
I have a question.
Yes?
So when you were talking about with the sibling exception that the mom wanted to raise it, so can that apply when you've got a parent who has a child that was never subject to jurisdiction in this court system, and so does that mean that we can raise the sibling exception as the parent?
Yes.
That's
Yes.
what that case law stands for.
Yeah, well, it stands for the
Without
fact that you
being
can't
different.
deny her the opportunity to testify about the application, the only exception she had available to her to challenge the termination of parental rights, freeing the child from adoption.
And just while we're on the subject of these exceptions, so you guys, the court does not have to give you a hearing. So that's Grace P. You have to make an offer of proof. They can ask you to give an offer of proof. You better give as many facts as you can possibly give to persuade that bench officer to give you a hearing. The burden is on you guys. All the court has to do is find that the kid is adoptable. That's all that hearing is about. You guys want to go forward on the exceptions, give a really, really detailed offer of proof, which is what happened here. This came out of this courthouse. The attorney gave, I'm glad you said it because I knew it was you. The attorney gave an extremely detailed offer of proof, and the trial court was like, I don't need it. The Court of Appeals said, no, you need it. You need to be heard on all these issues, because what the trial attorney did was she talked about things that weren't even in the reports, to what beyond the reports.
Thank you, guys.
Thank you all for coming and listening, for laughing and sharing, and feeling our